Imagine a courtroom drama that could reshape the American political landscape, potentially handing Republicans a powerful tool to redraw electoral maps and dominate Congress for years to come. This isn't just speculation. It's the real stakes in an upcoming Supreme Court ruling on voting rights that has democracy advocates on edge. But here's where it gets controversial. If the court strikes down a crucial part of the Voting Rights Act, it might unleash a wave of changes that some see as necessary fairness, while others view it as a dangerous erosion of protections for minority voters. Stick around to uncover the details, and you might find yourself questioning just how fair redistricting really is. Out front of the U.S. Supreme Court in Washington, D.C., back in March, protesters waved signs demanding protections for minority voting rights, capturing the tension around this pivotal moment. Photo by Jamal Countess, Getty Images for Legal Defense Fund. The High Court is set to revisit a significant redistricting lawsuit this Wednesday, with implications that extend far beyond one state. At its core, the case could decide the viability of Section 2 of the Voting Rights Act, a federal law designed to prevent racial discrimination in elections. If overturned, this might allow Republican-led states to adjust congressional district lines in ways that favor their party, potentially securing dozens of additional House seats. A new study from advocacy groups Black Voters Matter Fund and Fair Fight Action highlights that at least 19 House districts could shift Republican-leaning based on current maps in GOP-controlled areas, and this is the part most people miss. Depending on when the justices deliver their verdict, in Louisiana versus Callais, some of these redrawn districts might take effect before next year's midterm elections. This timing adds urgency as President Trump and GOP leaders push for updated maps in places like Texas, Missouri, North Carolina, and beyond, aiming to solidify their narrow House majority heading into 2026. The potential fallout from weakening Section 2 is profound. This provision has long guarded against the dilution of minority voting power, a concept where district lines are drawn to minimize the influence of communities of color, making it harder for them to elect representatives who share their priorities. Experts explain that without these safeguards, mapmakers could create districts that fragment minority populations, reducing their collective impact on elections. Think of it like this. In a game where teams are formed, you wouldn't want the rules to stack the deck against certain players. Section 2 ensures everyone has a fair shot at winning. Critics of the provision argue it's outdated, comparing it to affirmative action policies the court already dismantled in college admissions. They contend that using race as a factor in drawing maps is inherently unfair and unconstitutional, much like race-based preferences in education. But supporters counter that it's essential for correcting historical injustices, where discriminatory practices once barred minorities from full participation in democracy. Many defenders of the Voting Rights Act are alarmed, especially after the conservative-leaning court opted for a rare second set of oral arguments last term, focusing on whether Section 2's requirements align with the Constitution. If the court rules against it, the ripple effects could be enormous in the South, where Republicans hold strong majorities in legislatures and gubernatorial offices, and voting patterns often divide along racial lines, with Black voters typically supporting Democrats and white voters leaning Republican. Without Section 2's oversight, states like Louisiana, Florida, Georgia, Missouri, North Carolina, and Texas might end up electing fewer Democratic representatives. The report suggests that Alabama, Mississippi, South Carolina, and Tennessee could even see all their Democratic seats vanish. Moreover, up to 30% of the Congressional Black Caucus and 11% of the Congressional Hispanic Caucus might disappear, fundamentally altering the voices in Congress. Cliff Albright, co-founder and executive director of Black Voters Matter Fund, warns that this isn't just a regional issue. What we're emphasizing in this report is that events in the South have nationwide consequences, he explains. Racial gerrymandering doesn't stop at state lines. It can strip power from Black and Latino voters nationwide, erasing elected officials who represent their interests, and reshaping the entire country's political balance for generations. Delving into the Louisiana case, which sparked this debate, a lower court mandated that the state's GOP legislature redraw its congressional map after black voters filed a lawsuit citing Section 2 violations. The resulting map, used in the 2024 election, helped Democrats gain a second seat in Louisiana. But now, a group of white voters, represented by Philip Callais, claims that incorporating race into the mapping process is unconstitutional. They draw parallels to the 2023 Supreme Court decision ending race-based affirmative action in higher education, urging the court to similarly ban race-conscious districting. In a twist, during the rehearing request, the Supreme Court instructed parties to examine if creating a majority-minority district infringes on the 14th or 15th Amendments. Louisiana's Republican officials have doubled down in their briefs, opposing any race-based considerations in redistricting whatsoever. Surprisingly, the Trump administration's Justice Department has shifted stance, now arguing that Section 2's anti-discrimination measures are no longer constitutionally valid, a stark reversal from prior years. Just 2 years ago, the court upheld Section 2 in a similar Alabama case, rejecting Republican claims. Yet, observers like Atiba Ellis, a professor and associate dean at Case Western Reserve University's law school, worry the tide is turning. The court might reaffirm the act, as in the 2023 Allen v. Milligan decision, Ellis notes. However, there's growing skepticism about race-conscious fixes for civil rights issues, and this case could mark the point where the judiciary curbs Congress's ability to foster inclusive democracy. Amid the current redistricting battles, such a ruling might spark an unconstrained scramble for power, especially following the 2019 decision that federal courts can't intervene in partisan gerrymandering. Ellis emphasizes the gravity. Politicians from both parties have always pushed boundaries for advantage, but Section 2 has been the key barrier against racial bias. Without it, the fallout could be catastrophic, echoing through decades of elections. Time is running out for new maps before the midterms, with state deadlines looming. Louisiana's Secretary of State, Nancy Landry, has petitioned the court for a decision by early January 2026 to keep the process on track. Still, the justice's schedule is uncertain, as major rulings often come late in their June term. Meanwhile, the court is eyeing related cases, like one from North Dakota questioning whether private groups can sue to enforce Section 2, and another from Mississippi raising similar concerns. This brewing storm over voting rights isn't just about legal jargon. It's a clash of visions for America's future. On one side, there's the push for colorblind processes, free from what some call divisive racial quotas. On the other, advocates champion measures to heal deep-seated inequities, ensuring that democracy truly represents all voices. But here's where it gets really intriguing. Could eliminating race-based redistricting actually level the playing field, or does it risk reinforcing old prejudices under a new guise? And what if the court's decision sets a precedent that allows unchecked partisan manipulation, turning elections into a free-for-all? We'd love to hear your take. Do you believe the Supreme Court should preserve Section 2 to protect minority voting power? Or is it time to move past race-conscious policies in elections? Share your thoughts in the comments. Do you agree with the critics, or do you see this as a threat to democratic fairness? Let's discuss.